everyone. The Minnesota Senate Labor Committee is called to order. Welcome back. It's good to see everybody, and we do have some new faces here, new members, new staff, and so I'm just wondering if, for the benefit of everybody, if we could do some quick introductions of new members and staff, and maybe we could start over to my right with Senator Rarick, who is back on the Labor Committee. Welcome back, Senator Rarick.
Thank you, Madam Chair. I guess technically I'm a new member, but I did serve for a couple weeks last year and was the previous chair of this committee, so appreciate being back. But yeah, so Senator Rarick, District 11, so Rush City up to Cloquet area.
Thank you. And next we have Erica Bird, our new fiscal analyst.
Thank you, Madam Chair. My name is Erica Bird. I'm a fiscal analyst with the Office of Senate Council Research and Fiscal Analysis. I started with the Senate in late 2025, and I'm new to this committee this year. And I'm looking forward to helping this committee with any fiscal and analysis needs. Thank you.
Welcome. And next to my left, we have our new committee legislative assistant, Sean Lynn. If you could give yourself a little introduction.
Hi, thank you, Madam Chair. My name is Sean Lim. I use he, him pronouns, and I'm the new committee legislative assistant for the District 8 office. And we also have our two pages. Oh, thank you for coming. I was like, could you please come up? But then there you are. And Brooklyn Carlson and Finian Joyce Velez. Did I pronounce that right? Please go ahead and introduce yourselves if you wouldn't mind as well. Welcome.
Hi, I'm Brooklyn, and I'm from Andover, Minnesota.
Hi, I'm Finian, and I'm from Roseville.
Thank you very much. All right. So welcome back, everybody. It's really good to be back and to be the chair of this committee. I really enjoy our meetings together and the work that we do together. Just as a matter of logistics, I just wanted to make sure people know that later this week, on Thursday, we will not be having committee on Thursday, but we'll look forward to next week and are planning ahead for a busy session. I'm going to go ahead to move on to the next agenda item that we have after our introductions, and that is the presentation of the Plumbing Board. If the members who are here from the Plumbing Board would please come up and join us. Welcome to all of you. Please go ahead and take some time to introduce yourselves and proceed with any statement or information that you would like to share with Senate Labor Committee.
Yeah, thank you, Madam Chair. I'm Carl Abrahamson. I'm the board chair.
Madam Chair, I'm Richard Becker. I'm the licensed professional engineer position on the board.
Madam Chair, Jonathan Lemke. I am the industrial, commercial, and the secretary for the chair, or board.
Thank you. Good afternoon. As I stated, my name is Carl Abrahamson. I serve as the chair of the Plumbing Board, and on behalf of the board, thank you for the opportunity to meet with you today and describe the board's work and mission. The Plumbing Board was created in 2007 and replaced the Plumbing Code Advisory Committee, which had served from 1997 to 2005. The board consists of 14 members, 12 of whom are appointed by the governor with the advice and consent of the Senate and who represent a variety of perspectives and segments of the industry. Pursuant to statute, these 12 appointed members must include 2 municipal plumbing inspectors, 2 commercial or industrial plumbing contractors, 2 commercial or industrial journey workers, 1 licensed professional engineer specialized in plumbing design or systems, 1 residential plumbing contractor, 1 residential plumbing journey worker, 1 water conditioning contractor, 1 municipal plumbing water supply system operator or superintendent, and 1 public member. Whenever the statute requires 2 members of a certain occupation, as in the case of municipal plumbing inspectors, one must represent the metropolitan area and the other must represent Greater Minnesota. The board also includes a designee of the Department of Labor and Industry, who is a voting member, and a designee of the Department of Health, who is a non-voting member, which gives the board a total of 13 voting members. The board's primary duty is to adopt a modified version of the Uniform Plumbing Code as a Minnesota Plumbing Code. The board modifies the Uniform Plumbing Code to tailor its provisions to meet the unique needs of Minnesota and to coordinate with the policies of other state agencies. In doing this work, the board's paramount concern is always to protect the health and welfare of Minnesota. Presently, the board is finalizing its work to adopt a modified version of the 2024 Uniform Plumbing Code, which will become the latest edition of the Minnesota State Plumbing Code. This work has been underway for over 2 years, and we anticipate a formal rulemaking procedure will commence this spring. In addition to promulgating the Minnesota Plumbing Code, the board is vested with the final interpretive authority of the code, meaning it can respond to requests for interpretation of the code and to petitions for variances from code requirements. Finally, the board is responsible for adopting rules to regulate the licensure of plumbing contractors and continuing education requirements for plumbing contractors. However, the board is not the body responsible for enforcing the code. By statute, the board must refer any complaint of an alleged code or licensure violation to the Department of Labor and Industry. Thank you again for the chance to introduce the board's work and its members, and I'm happy to answer any questions you have.
Thank you very much. Members, the terms of half of the plumbing board members expired in December, and their appointment paperwork has not yet come through. And in a moment, I would like to propose that we move to recommend the members that we can act on at this time and then take up the others when we are able to. If you will notice in your folders, we have a nice write-up of the plumbing board member biographies, if people want to take a look at that. And then we also have copies of the notice of appointments for 6 of the plumbing board members. Before we move to that, do any of the members have any questions for the members of the plumbing board who have joined us today for their presentation? Are there any questions and comments before I would move ahead and ask for a recommendation to have the Senate to move the appointment of those members? Any questions or comments? Yes, Senator Dornick.
Thank you, Madam Chair. I just wanted to thank you for the work you do. I see you meet 6 or 7 times, is that right, in a year?
Thank you, Madam Chair. Senator Dornick, right now we're meeting monthly because we are actually trying to get the plumbing code revisions done. We're hoping to get done in the next month or 2 so we can move it forward to the, in the rulemaking process. Thank you again.
Yep. Thank you. So yeah, I just wanted to just thank you for your work and all that you guys do as you work through some of those issues. So thank you.
Thank you, Senator. All right. Seeing no further discussion, I would like to propose that we move to recommend the members, as I said, that we can act on this time, the 6 members of the plumbing board whose paperwork we've received, their notice of appointments. So would someone like to move to recommend to the Senate the appointment of Richard Becker, Kent Erickson, Adam Johnson, Jonathan Lemke, Justin Perizek, did I pronounce that right? Perizek, and Philip Wood to the plumbing board be confirmed? Thank you, Senator Dornick, for making that motion. All in favor, say aye. Aye. All opposed, say nay. All right, the motion passes. Thank you very much for taking the time to come here today to present to our committee and to talk about your work. And as Senator Dornick said, thank you for the service that you are all doing for the people of Minnesota through the use of your expertise and coming together and performing the work that you do. Are there any last comments that you'd like to share with us in conclusion?
Thank you, Chair McEwen. I don't have any comments at this time. I appreciate you guys giving us the opportunity to come and speak in front of you and answer any questions you may have.
Great. Well, stay in touch. And of course, if there ever are any issues that you'd like to come to the committee to speak with us about, we'd love to have you anytime. So Thank you very much for coming.
Thank you again.
Thank you. Okay, next on our agenda today is a presentation on the 2026 Women's Economic Security Act Annual Report by the Department of Labor and Industry. And joining us today is Mr. Fouad Ali from the Labor Standards Division of the Minnesota Department of Labor and Industry, as well as Josiah Moore. Welcome. And if you'd please introduce yourself for the record and then proceed with your presentation. Thanks very much for being here.
Hello, members of the committee, Chairman McEwen. My name is Fouad Ali.
Could you please move the mic a little bit closer?
Yeah,
Sorry,
my name is
thanks.
Fouad Ali. I'm a supervisor with the Labor Standards Unit at the Minnesota Department of Labor and Industry. I will be presented today on the Women's Economic Security Act. The acronym is WESA, specifically on the 2025 report, which is a report the department is mandated to submit to the legislator in terms of its complaint data and the rate of resolution. Next slide, please. So in the course of this presentation, I will be talking about the background and the enforcement authority that DLI has, the WESA provisions that are enforced by the department, the innovations we've had over the course of the past reporting period in terms of enforcement and outreach, and I will cover the complaint data and the trends we are seeing over the course of the last 3 years. So WESA was passed in 2014. It has gone through a number of revisions in 2022, 2023, and 2024. It's designed as a comprehensive worker protection law because it tackles more than one area in the workplace rather than focusing on one single issue. More importantly, it aims to improve the women's economic security in the workplace. It includes 4 provisions that are enforced by the department. The first being the wage disclosure protection, and that particular statute, really briefly, requires employers or prohibits employers from stopping employees from sharing their wage information and general employment conditions, and prohibits them from taking any adverse action in terms whenever an employee does so. The pregnancy accommodation law briefly provides employees facing pregnancy or pregnancy-related health conditions to be able to receive reasonable accommodations in the workplace. And there are specific accommodations for which employers may not seek medical certifications. Those are specifically seating, extra breaks, and the ability to consume food, and limits on lifting 20 pounds. The pregnancy and parenting leave law provides employees who are in conjunction with the birth of a newborn or an adoption of a child to have access to 12 weeks of unpaid leave with the ability to be reinstated back after the leave is over. And it also requires employers to maintain health insurance coverage during that time when the employees will be on leave. Both laws have anti-retaliation provisions embedded within them, and it requires employers not to take any retaliatory action whenever an employee asserts any of those rights. Nursing mothers and lactating employees is generally a law that provides nursing mothers and lactating employees the opportunity to be able to express breast milk in the workplace, and it requires employers to provide or make reasonable efforts to provide a space that's clean, secure, and private in order to express milk in the workplace. Next slide, please. So DLI Enforcement Authority. DLI is vested with the authority to investigate complaints, issue compliance orders, including reinstatement to employment, assess back wages, compensatory damages, and liquidated damages anytime there is an employee affected by a WESA-related violation. For complaints related to nursing mothers specifically and pregnancy-related accommodations, DLI is mandated to contact the employer within 2 days and attempt to resolve the complaint within 10 days of receiving a complaint and obtain a resolution within those 10 days. Next slide, please. So we've had a number of innovations in terms of methods and approaches we've adopted over the course of the last reporting period. Informal resolutions make up the largest sum of DLI's investigations when it comes to WISA. DLI, as I said, is mandated to attempt informal resolution, educating employers about their legal obligations and asking them to voluntarily come into compliance has been a successful approach to achieve compliance for DLI. And that's clearly illustrated in our last report, where it shows that we've had a total of 116 complaints resolved informally out of a total of 123 complaints received in that reporting period. We have adopted new methods such as instituting pre-enforcement demand letters. Those letters are used to alert employers of violations identified during preliminary investigations. It details the form and nature that a given violation is taking place, and it prescribes the necessary corrective action to achieve full compliance. We've issued those particular letters in cases involving serious violations, particularly when employers appear to have been willfully non-compliant with the law, and when violations resulted in significant loss of wages to pregnant employees. And this particular use of letters aims to speed up the informal compliance process and avoid protracted legal processes. DLI issued a total of 19 pre-enforcement letters in the past reporting period. Next slide, please. Other innovations that we've achieved in the past reporting period include being engaged in targeted strategic outreach efforts. We have reached out to resident physicians specifically. In the preceding reporting periods, we have partnered with an OBGYN and introduced sample language to be used into return to work letters that make specific references to the protections under WISA that employees can take back to their employers that can help facilitate their ability to receive the protections under the law. We have created training material and administered training to resident physicians in one of the major health systems in Minnesota. Because resident physicians are still in training, it was important for us to reach out to them and give them an overview of WISA and the protections that it entails, and in hopes that that will reach the impact that the work that we're doing will impact other settings and their future patients in terms of introducing similar return to work letters that they can adopt and implement into their respective practices. We've collaborated with our DLI recipients, grant recipients. We have had grant recipients organize a number of workshops in which more than 70 practitioners were part of, including medical doctors, doulas, and certified nurses and other organization staff that work with families. In those workshops, we have provided an overview of the law and the provisions of the law, the protections. It created avenues to have conversations and build some practical knowledge around the law, and basically help better support their clients into their future in terms of how the law can protect their rights. Third-party administrators are organizations that employers tend to outsource administrative work to. Our investigative work showed that third-party administrators were drivers of incompliance in the area of WISA, and that is because employers tend to outsource a very important part of the process, which is the interactive process, which is when an employee and employer are discussing their needs and figuring out what is the best way to accommodate them. So it was essential for us to make sure that we reach out to one of the biggest third-party administrators that work with Minnesota-based employers. And we have created training material that was driven from our investigative files that really provided real life scenarios that explained how third-party administrators were driving in compliance. And that was the training material. It was based on their own practices and their own business models to help them understand how to be more cooperative with compliance and kind of, achieve more through that by influencing their conduct. Obviously, they work with so many employees in Minnesota, so if they were the ones that receive this training, they will be able to influence compliance across many, many workplaces in Minnesota. Lastly, staff and agencies. Our investigations have indicated to us that they are a major player in achieving compliance in this area of the law. Obviously, they recruit a lot of workers to many employers in the state, so you have these joint employment relationships that staffing agencies enter into by virtue of oversight they have of the employees that they recruit. After they place them into their client employer's sites, they continue to have contacts with them. So we've created training material that help explain that dynamic and basically the dual liabilities and dual obligations that being a joint employer entails in hopes to also influence compliance in this area. Next slide, please. So this is the raw data that we have to present to you today. It's based on the period of September 2024 through August 2025. This is our intake data. It represents contact with stakeholders, others in person, at our offices through our hotline or email correspondence or letters to the division. We've had a total of 675 total WISA intakes, and it gives you the different numbers in terms of the respective areas of the law in terms of the exact number of intakes we received. And those numbers were basically the basis for what we eventually took on as complaints and thereafter as investigations that we delved into. The next slide provides a breakdown of the total investigations we have conducted over the past reporting period. Those are a total of 123 investigations in total. We have received, we closed 118 out of those 123 and made findings in 118 instances. And the table provides you information about the different provisions under the law, the number of complaints we received, and violations found. If I may explain so employee notice, you would see that, for example, we've had 12 complaints come in, but we found 34 violations, and that is because even though we only had 12 complaints specific to that area of the law, our investigations have found more violations specific to that. Next slide, please. So this one talks about the overview over the last 3 years. Progressively, you will see from August 23rd, the period ending in August 2023, we only had a total of 24 complaints. That number rose to 77 when it comes to the period ending in August 2024. Then the last period ending in August 2025, that number almost more than doubled to 123, which represents 59.74% increase. When you look at the change between 2023 to 2025, that's more than five-fold increase in the total number of complaints and investigations we looked at, which is more than 412.5% increase in the total number of investigations. So DLI was successful in informally resolving most complaints. We've achieved a resolution rate of 94.3%. And that was achieved primarily through educating employers about their legal obligations, which resulted often in corrective actions voluntarily. Over the last reporting period, DLI secured voluntary agreements from employers to pay a total of $81,574.10 specific to this area of the law, and in back wages, compensatory damages, and liquidated damages to a total of 21 employees that were impacted by a WISA-related violation. We've issued a total of $40K in civil penalties and stayed a total of $160, pending further compliance with the law. Next slide, please. In conclusion, I would like to say that DLI will continue to focus on education to both employees and employers about their rights and responsibilities under WISA. Informal resolution of complaints is the agency's primary enforcement tool, and most employers willingly and expeditiously come into compliance. We will continue to support pregnant and new parents in the workplace to protect their safety and economic security, and help employers comply with the law will continue to be DLI's goal into the future. And that concludes my presentation. Thank you for your time.
Thank you very much for this presentation. I have some comments and questions, but first I wanted to open it up to our members. Senator Marty.
Madam Chair, thank you. Just a quick question on the one you pulled out on the retaliation complaint data. You had, or excuse me, the employee notice, you had 12 complaints and you closed 34 with 34 violations. Was that those 12 employers and you found they had failed to provide notice 3 times as often? Or was that these notices you were investigating, say, a pregnancy accommodation one and found that they had not provided notice?
Correct. So it will be both, Madam Chair, if I may say.
Please, go ahead.
So yeah, it's both. There's been instances where we received complaints specific to employers not providing the notice requirement, and there's incidences that, another complaint will come under a different provision, like pregnancy leave, for example, in which we find that the driver for incompliance meant the failure to provide notice in the first place. So that's how those numbers come about.
Thank you. Senator Kupek.
Sure. Thank you, Madam Chair. And in a similar question, so also noticed there's a lot of intake data, but then it led to the investigations are much smaller. So some of the data that you intook, were those people resolve them on their own, not credible? I mean, what were the reasons that they did not lead to, I guess, an investigation?
Mr. Ali.
Yes, Madam Chair. So the intake data represents email correspondence and telephone calls where people are asking for brief information about the law in general, what it entails, what are the protections in place. So those were often resolved over responding to an email or quick conversation over telephone. The ones that are basically ones that people are complaining about prospective violations of the law are the ones we look into converting into a complaint, where we mandated to take all complaints that we receive. And yeah, I hope that answers your question. Thank you.
Thank you. Members, any other questions or comments? Yes, Senator Umer Verbaeten.
Thank you, Madam Chair. I was looking at the slide on investigative data where there's a 5-fold increase, and I apologize if I missed some of this, but what do you think accounts for that? I'm curious if you've found different outreach partners that maybe have helped more folks understand their rights, and then that has led to a larger increase, or did you have more staffing and ability to handle complaints at DLI? If you could just share a little bit more of what's led to that.
Mr. Ali.
Madam Chair. Yes, I would say all of the above. Our staff has increased significantly in numbers of staff that can investigate these type of complaints. So we have more capacity. That's number one. Number two, we've been very innovative in reaching out to stakeholders. We've implemented a number of different approaches that I've went over in the presentation that really enabled us to reach our targeted audience and make sure that people who really need this information receive it and learn it and know what it is, and therefore come back to us when there is instance of violations. So it's a testament to our outreach efforts, as well as our efficiency to be able to investigate more and achieve resolutions much faster.
Senator, follow-up?
Yeah, thank you, Madam Chair. Just a comment. Thanks for that explanation. And I did catch you talking about reaching out to resident physicians and doulas and maybe some folks that if you are, pregnant or parenting, would already be accessing those services. I think that's a great way to try to find your targeted audience. And I don't think it's necessarily a bad thing to see an increase in complaints, especially because you've been so successful in resolving those complaints with the, 94.3% success rate. People just need to know, right, their rights. Employers need to know what their obligations are, and I know that you really try to resolve things on the front end and come from a place of education and understanding and not this punitive approach. So grateful for the work. Thank you.
Thanks. Yes, Senator Weisenberg.
Thank you, Madam Chair. They brought up retaliation, so I guess a question that was in my mind, are you working with any of the women whistleblowers within the DHS that were ignored or threatened with job loss for speaking out about fraud?
Thank you, Senator. Please, Josiah, or Mr. Moore, please go ahead and respond if you would like to.
So as far as enforcement under WISA, we just wouldn't have any jurisdiction to take any action. The enforcement under WISA is narrow retaliation protection specific to the WISA statutes. So long way of saying no, we wouldn't be involved in that.
Follow-up, Senator?
Thank you, Madam Chair. So I guess broadly then, so retaliation, so is WISA, this is protections for women, correct? So and this is the Department of Labor and Industry, so if anyone's working, they come to you if they have a concern, correct, if they're a woman? So any woman that works, if they have a concern about being retaliated against, even, let's say, even in schools or something, if they're worried, they come to you because if they would have a concern and you would help them, I'm guessing, right?
If either of you would like to field that, please feel free, but
Yeah, just to clarify, Madam Chair, thank you. The retaliation provisions are specific to two areas, actually 3 areas of the law. The ability to receive breaks to express, the ability to receive parental leave. Those are the two, and being able to be reinstated after the leave. So those are specific to pregnant employees who are pregnant or post-pregnancy when they have their children. They're both childbirth, and they continue to face barriers to employment because of the childbirth process and so forth. But also male employees who also have right to leave of absence in conjunction with the birth of a child. So either of those two, if they were to face any retaliatory action that results in an adverse employment action, that will constitute retaliation for which we would have to investigate. And that's what those numbers are referring to. Retaliations that occurred after an employee has asserted those specific rights in the workplace, as WISA states.
yeah, so it's WISA specific. Yes, Senator?
Thank you, Madam Chair. So WISA only pertains to pregnant women or pregnancy-related things, and taking leave of absence is what you said then?
There's a few other provisions, like the wage protection, wage disclosure protection, and ability to take leave for school-related activities. Those are also other provisions that are under our jurisdiction. But the 4 main ones are the ones that I've discussed in the course of the presentation.
Thank you, Madam Chair.
Thank you, Senator, and thank you for the response. I think, too, on the, I think it's the second or third slide, in the slide, a copy of the slides is in the packet. On the second page of the packet, it goes through sort of what laws are part of WISA, and Mr. Ali went through that. So the wage disclosure protection, pregnancy accommodation, pregnancy and parenting leave, and then nursing mothers and lactating employees as well. Yes, Senator River Benton.
Thank you. I just thought of one other question. Part of why I was also late here is because I'm a new nursing mother, so needed to take those breaks. And I was actually just meeting with a group of students, student parents, who were talking about some of the barriers that they face being able to fully participate in education. A lot of that's probably going to be more in our work in higher ed, but I am curious, like, what authority you may have over folks who would be students but maybe working as a part of their education. if they're like graduate students, need to do certain work in order to complete their degrees, or if they're working on a campus job. I don't know if council would know that either, but I'm just curious for those folks who may be kind of a student but also working, would they fall under WISA?
Mr. Ali?
Madam Chair, yes, there is no any specific number of hours you need to be working in order to be protected by WISA when it comes to the ability to express in the workplace.
Okay, thank you. All right. I would just also offer my thanks very much. Thank you very much for your work in this area and for coming today to present us with this report and the findings. I echo the sentiment that we've heard about the higher numbers. That was also the question that I was going to pose. And to me, additionally to what has been said, it also strikes me that just the awareness of how many of these rights violations, how many barriers people were experiencing already, but maybe didn't know that that isn't the way that it had to be, or that they had some ability to ask for help and correction in their workplace. So people were living with that. Some people were losing wages. The number that you showed us of the wages that you recovered, over 80, almost 82, closer to $82,000 in back wages. That's real money in people. Like, for a working person to get back money that you had been owed and that you hadn't received in the first place, that was going to go to your rent, that was going to pay for your regular everyday living costs, that really matters to people. And so I'm just so grateful to have this report from you, and to know that the laws that we have worked so hard, initiated here by our Senator Pappas back in the day, the initial WISA law, and then the work that we have all done together in these last years. I'm so happy to see it really coming around, and people feeling that they have recourse to be able to work and to parent and to be treated fairly and get what they need. Senator Pappas.
Thank you, Madam Chair, and thank you for the presentation. No, I was the author in 2014, as Madam Chair mentioned, and I love the idea of the reports, because a lot of times we pass laws and we have no idea if they're effective or not, or if they're working, unless we have some kind of a feedback loop. And so I appreciate you coming in and telling us about your work. Thank you.
Thank you very much for coming. If you have any final remarks, please feel free, but we just want to thank you very much for the presentation today and for your work.
No, thank you very much. I appreciate the opportunity. Thank you. Enjoy the rest of your day.
Thank you. You too. Okay. Next, members, on our agenda, we have Senate File 3719, which is my bill. I'm just going to stay. These are two agency bills that I am going to, I'll just remain up here. I am the one carrying these bills, 3719 and then 3720. But Mr. Moore is joining us today, and I am going to, for the first bill, 3719, turn it over to you, Mr. Moore, for the presentation of the bill, and then any discussion that we have as a committee. Mr. Moore.
Good afternoon, chairs and members of the committee. My name is Josiah Moore, and I'm the legislative director at the Minnesota Department of Labor and Industry. I'm today going to be testifying in support of Senate File 3719, which is DLI's bill to remove references in state statute to Class A electrical installers. This license type is a defunct license type. There are no current holders of this license in the state, and there is actually no longer a path to acquire this license. So as such, this bill is just pure cleanup and won't have an impact on the industry or electrical contractors in the field. And that is truly all that is in this bill. So I thank you and welcome any questions.
Thank you very much, Mr. Moore. If everyone has had a chance to kind of take a quick look at 3719, are there any questions about this bill or discussion? Okay. Seeing none, that bill 3719 is going to be laid over. So it is laid over. Thank you very much. And now on to the next agenda item, Senate File 3720. Likewise, the bill that I am carrying, and I will, first, there is a technical amendment. There's an A1 amendment for Senate File 3720 to delete Section 2. Mr. Moore, could you just run through the A1 amendment real quick, the deleting the Section 2?
Yeah, absolutely.
Before we move that amendment.
Yeah. So the author's amendment deleting Section 2. Section 2 would have added plan review to the list of services that shall be delegated to a qualified municipality under 326B.107 sub 3 there. Currently, there's a municipal delegation technical advisory group that's been convened by the Construction Codes Advisory Council. And when they discussed this addition of plan review, they recommended against including it. So that's why we've proposed removing Section 2 of the bill here. And I'll also just note that functionally, DLI does already have the authority to include plan review in these delegation agreements. If you look in the bill as introduced on line 2.24, the very last line of it, includes other projects determined to be reserved by the commissioner. So in situations where delegating plan review is appropriate, we do already have that authority.
Okay. Thank you very much, Mr. Moore. So I would like to go ahead then and move the adoption of the A1 amendment to Senate File 3720. Any discussion? All in favor, please say aye. Aye. All opposed? All right, the A1 is adopted. Mr. Moore, do you have further comments to tell us about Senate File 3720?
Yes, I'll note again that this is a DLI technical bill, and I do express my support for it today. You'll notice the remaining pieces of the bill update references striking phrases like inspectors and inspections and replacing them with persons and code enforcement staff. This is done simply because when we delegate to municipalities, the staff performing that work are not limited to just being inspectors or performing inspections. They perform a slightly broader scope of work than inspections. So this is just updating the statute to clean it up to reflect more clearly what happens in these delegation agreements, but it won't have a substantive impact on how we go about doing these delegation agreements with municipalities.
Very good. Thank you, Mr. Moore. Members, any questions about Senate File 3720 as amended or discussion? All right, seeing none, I would note then that Senate File 3720 as amended is laid over. And members, that concludes our business for today. Thank you so much for joining us, and I look forward to seeing you all again soon. The Senate Labor Committee is adjourned.